Well, thank you. And I just want to thank everybody for organizing this today. It's an emerging topic, you might say, and thank you especially to Mary for putting it all together. I was at a seminar in Toronto for lawyers. It was important enough that I went on a Thursday night on January 15th, 6 o'clock at night. And the general theme is that these are emerging issues. Like the lawyers, the experts in the room didn't know the answers to many of the questions. And I think just talking to people here, we have a fairly wealthy society now. We have baby boomers coming forward, I guess born between 1946 and 1964. We have a lot of people coming forward. And these are going to be new problems. People are living a very long time. And so the issues of power of attorney come forth and capacity. And I have a feeling that the people before me may have covered some things I've already covered, so I'll try and keep it short and maybe have a few questions at the end. First of all, just going through the scope of power of a power of attorney. It's very, very broad. The power of attorney has a lot of power. The only thing they can't do is they cannot make a will. And in that scope of authority, they also have a very high duty of diligence to be honest and to act with integrity, and they're held to a very high standard. So I think the last speaker sort of, when I heard him talking about what a big job it is, how important it is, and the big responsibilities, absolutely right. The discretion of the power of attorney, again, they have a fairly wide discretion. Their job is to look after the incapable person. So their decisions are to be for the benefit of the incapable person. And that includes making sure they have a place to live, making sure they have enough money to live the standard that they have. And when it gets to that, the kind of discretion is very, very difficult. And I've seen people have to make this decision, is the incapable person wants to live in their house, but they aren't able to financially do that because it's going to cost. I saw one bill, $96,000 for full-time care in a home for a year. And that is a decision that the power of attorney might have to make, actually. So it gets into the power of attorney for property, dealing with money, also gets into the personal care issue. They are very connected because it really is about the personal care and the personal well-being that the guardian for property or the power of attorney for property is acting. And on that issue of, then we go on to inter-vivus gifts and charitable donations. This is a common question, and loans, quite common. Power of attorneys ask me, can I give gifts? The previous speaker talked about giving out the estate ahead of time, which would seem to make a lot of sense in some cases, but really they can't. The decisions of the power of attorney always have to be in the best interest of the incapable person. Any gifts would have to be in accordance with the living the way the power of attorney had spent their money before they became incapable, and the same with charitable donations. And they also can't exceed, I think it's 20%. It's 20% of the incapable person's income per year. And those become my advice to people is just don't do it unless it's a small amount of money. I mean, if the incapable person gave $1,000 every year to the local church, you're going to be fine. But anything more than that, and if they gave $100 to every child at Christmas, I think you're going to be fine. The same with loans. If the loans were approved before the person became incapable, you probably can continue it, but you want to be really, really careful. And I just advise people don't do any of these things without spending a fair amount of time on it. Also, those issues are going to they're going to be emerging in law. We're going to see new decisions on this because you can, just from the previous speakers today, you can see there are some problems with power of attorneys where people go beyond their powers. And I would suspect that we may even see new legislation about gifts and loans and that sort of thing, very, very specific legislation in the next while. Now, something I just go through, I don't know whether other people did or not, but the power of attorneys have to keep very, very detailed accounts. And I was power of attorney when I was in politics for elderly man and king, and he was worth a fair amount of money, and I really had no choice because if I had not acted, we wouldn't have been able to pay his bills. So I worked very closely with his wife and daughter. We've remained very good friends, and as soon as we had a gerontology psychiatrist at the Toronto Rehabilitation Hospital declare him valid, meaning capable again, I can tell you I was out of there very, very quickly. But I'll tell you, nobody questioned anything I did because we actually put all of the expenditures and all of the financial information on our computer. We put it on a computer program. And I'll tell you, if I were a power of attorney, I'd be buying a QuickBook accounting program. Somebody's nodding their head there. But I would really keep track of the finances. I was going to talk about some of the issues I've seen at the end and some of the difficulties for people, and it relates to that. Now, compensation. The power of attorneys can be paid. And the amounts set out are about 3% of capital and income received, and about 3% of capital and income on disbursements, and then a management fee for managing the whole estate over a year, every year of 3/5 of 1%. On some estates, that could look like a lot of money, but I can tell you again, it's a very, very large responsibility. Mostly in family members, they often waive that, or they take a lesser amount when it's a family thing. And a little rider on that, the court can always override that. The court could give more, they could give less. Somebody can always make an application to the court. And my little thing here, who can contest? Under the Substitute Decisions Act, really anybody can contest. Your neighbor could bring a court action. Normally they don't do that because they have to hire a lawyer, they have to have a retainer, they have to go through the whole thing. But really, somebody who thinks that your power of attorney is not acting honestly, they could bring an application to make the power of attorney pass accounts. Now, pass accounts is quite an experience. It is a very, very detailed accounting toward the courts. I mean, every little cent. You would have, $15 interest received on the account from a bank account. It's very detailed, and you need to be able to back it up with various receipts. I remember being on a passing account a number of years ago where another lawyer was questioning a $42 fee that we had paid to Bell Canada. And and he was questioning whether it should be income or capital, and he wanted to see the bill. I mean, it just gives you an idea how crazy it can get and how detailed it can get. So I'm already starting on this. The detailed accounting, again, very, very detailed accounting. I would put it on computers. Income tax returns. People often don't realize that the power of attorney has to file all the returns. And they can be liable if they're errors, if they haven't filed them on time. So it's an important thing they need to know. And the problems I've seen. I guess one of the things is just how overwhelming it can be for someone. I saw a young man end up dying of a heart attack at 40. I'd been playing hockey just before that, and he had been not a power of attorney, an executive for an estate. And the stress on this poor guy trying to do this was pretty overwhelming. And I kept saying to him, well, why don't you let us act for you and do the legal work? He said, well, he didn't want to pay the legal fees. Well, I'm telling you, and I could see he was getting into trouble. He wasn't paying bills. We were getting reminder bills at our office for the estate. And so it can be a very, very large responsibility. Anyone who's not used to doing accounting probably doesn't want to take the responsibility, and you may want to work with an accountant. I mean, you could have an accountant work with you and do all the accounting and keep track of all the bills. In fact, that probably is a good idea. If you're not a bookkeeper or an accountant yourself, just hire a bookkeeper to keep track of everything so that you don't have to worry about the various details. And I see that we got an estate right now where we're trying to tie the money together, and we can't. And the executor somehow thinks that magically the lawyers will pick the numbers out of the air, but we can't do it without the backup. We need all the papers, and he's not getting it to us. I don't know how we're going to figure it out. We have all the banking details, but We just can't tie together some of the numbers. The other kind of problems, and the last speaker started on it, is where people don't get along, siblings don't get along, or the power of attorneys don't get along. My own personal opinion is that the best power of attorneys are your family. Your children, your spouse, of course, but I personally think, and this is just my biased opinion, other people may have a different opinion, but I think your children are generally the best people to be executors of your estate and to be your power of attorney. I also think if you have 2 children, for example, you would always make both. They never seem to understand why one is not appointed. And even in my own family, I was living in King near my father, and so I was power of attorney for him, and my sister lived about 200 kilometers away. And he, at 91, suddenly said, well, why don't, I think I should make you power of attorney. Seemed like a good idea to finally do that at 91. And my sister said, why did he make you power of attorney? So, and we're twins, by the way, I'm a twin. So I quickly, I really had to, mend some fences there because she didn't understand, even though she was, 200 kilometers away and had 3 children. I mean, she had a lot of other responsibilities. The good news is we never used the power of attorney, but I think she felt a bit insulted that she wasn't on it. I mean, it wasn't about, I wasn't using the power of attorney, but she just felt a bit insulted. And the same with executors. Now, at some point, there are just too many. And if you've got one in Australia and one here, and, there are some practicalities in both power of attorneys and executors in that they are near where the assets are. They, that normal family, you might have to sell a house under a power of attorney or under an estate. And you may want the person right there with the knowledge and being able to sign all the proper documents. Residency, this is a very interesting thing. A non-resident can be a power of attorney under our normal power of attorney documents without posting a security bond. If, however, you have to get a court order or you have the public trustee involved, they will make them post a security bond. And a security bond, I'm not sure the last fellow talked about that or not, but it's extraordinary. You have to apply to an insurance company. You have to list all your assets, your debts. You actually have to get a policy and get a security bond. And it is really time-consuming. And, again, I had to do that. I had a brother-in-law die in the Northwest Territories, and he and my sister-in-law were divorced, and they had a child who was 17. And somehow the Northwest Territories would only appoint a lawyer, and this was 1991. So I ended up getting appointed. Well, I had no idea what I was getting myself into. I had to post a security bond and I had to go to an insurance company. I had to put down my credit card, how much were on my credit cards. I had to put down my annual expenses, the whole thing to do that. So some of the things on these I've actually experienced myself, and it's something you don't want to be in. Of course, you just completely solve that by getting a power of attorney. The last speaker, again, talked about how easy a power of attorney is. Power of attorney documents are very, very easy. In fact, I've said to people, if you don't want to go to a lawyer and it's clear you're competent, then download the forms from the public trustee's website. So at least you have a power of attorney in force. I mean, you have to have 2 witnesses. They can't be people named in the power of attorney or married to people in the power of attorney. But it is so important that everybody has these documents. Now, healthcare professionals, clearly, I'm sure somebody today talked about it, clearly they can't be your power of attorney unless they're related to you, and that's for obvious reasons. I personally have not seen any abuse there, but I've certainly heard from clients their concerns about money passing to various healthcare people. Some of these stories may just be stories and we don't know, but certainly there are a lot of alerts about it. Maybe King City is just a very honest place and we don't have these problems. I don't know. Now, if you don't have a capable power of attorney and become incapable, it's very, very easy. It's either the public trustee or court order. There you go. They're both expensive. They're both time-consuming. They both require accounting, detailed accounting. My dealing with the public trustee's office has always been excellent. But again, they're a government office. They have to follow the rules. They have to go through all the various technicalities. And, for a simple power of attorney, which probably costs you a couple of $100, you avoid all of those kind of problems. One more thing on that. Power of attorneys are not age-related. I think everybody should probably have a power of attorney. An 18-year-old should probably have a power of attorney. Talking to one of my sons last night, who's 32, and we were talking about this, and he said, well, why would I need one? I said, well, what if you were in an accident? And my law partner's wife is a litigation lawyer, and she has been telling us everybody should have a power of attorney because they had someone, a 22-year-old in a serious accident, and he's incapable, and they have to get a court order to be able to act for him. So, probably everybody should have them. It's just very hard to ask a 20-year-old to make a power of attorney, but anybody can become incapable. We had a client who was about 40, and he was in a very serious motor vehicle accident, and he was incapable for about 6 months. And then he was fine. He's in a wheelchair, but his mental capacities are just excellent. But fortunately, he had a power of attorney, or it would have been a very, very expensive thing. They were talking about lawyers at the back. The lawyers doing that kind of law are just, what can I say? It's easy money. They're just bringing it in because you have to file so many things out with the public trustee or with the court. Little final thing is keeping original documents. What we're trying to do now is do a notarial copy of the power of attorneys, not just an original, but also notarial copies, because people often can't find the power of attorney. Or they can only find a photocopy. Now, you can store them in lawyers' safes. You can do that. But, lawyers move and various things, and you still might have a problem of not finding the original. So we try to make we keep a copy of ourselves, a notary for ourselves, and we suggest that the power of attorney, the people making it, keep a notarial copy as well as the original. Most of the banks, they don't need an original. They need a notarial copy saying that it's a copy of the original. Now, I just want to go back to something a previous speaker talked about, and that's this joint asset thing. Because the reason I was in Toronto at 6 o'clock on a Thursday night in January was the province of Ontario has just brought in some new regulations. Did anybody talk about that today? The regulations? Okay. And this is to do with the payment of probate fees. And somebody here in the second row, you knew about this. Okay. And it was important enough that as soon as I saw the course, I was downtown. Normally, the law courses you can do online. This one you couldn't. And I'm going down Monday night for another course. And so it was really excellent. I have to say, I just felt high coming out of there because you've sort of got all the experts sitting around in the room, about 150 people just talking about the issue. The province of Ontario is concerned because people have been not paying their probate fees. So now, within 90 days after you get probate, the proper name for probate is a certificate of appointment with a will attached or without a will. You must file a financial statement with the province of Ontario. This is a job for lawyers and accountants, I'm afraid. Probably just increased everybody's fees. And the amounts in there have to be as of the date of death. So, for example, today, I was with some people in my office on a new estate, and we could not get the exact amounts. In the past, we would say, oh, well, when she died January 15th, we've got the statement for January 10th. That's pretty close. We're okay. It's a few dollars one way or the other. Now we're going to have the exact statements as of the date of death. And they must be filed, and they can be audited. And it got even more interesting. The house. We have been generally using MPAC statement, lawyers in general, the MPAC statement for the value of the house. And I will actually say to clients, is that about the right amount? Does that seem like the correct amount? Because you're swearing under oath that this is the value of the real estate. And so that's how if we thought it was worth a lot more, we will get an opinion of value from a real estate agent. Now, it looks like when you're evaluating a house, you'll need the impact statement, and you may need a formal appraisal. The people from the ministry at the meeting last week said they probably will take an opinion of value from a real estate agent, but they don't know. I think that was the interesting thing about it. Nobody knew. The expert lawyers didn't know, and the ministry didn't know. But I'll tell you how detailed it got. In the form that they have, it says you must list all your vehicles, ATVs, and bicycles. You can appreciate what the lawyers in the room thought of that. And we asked one of the ministry people who said she knew somebody with a $10,000 bicycle. I don't know, but I'm thinking I'm not listing bicycles, but it gave you the kind of detail, and this is going to be a new requirement. And it's going to mean that estates will take longer to settle because you'll probably want to hold back a fair amount of money until the ministry gives a clearance. And the ministry were talking about giving a clearance requiring the certificate from the federal government. There's a clearance certificate. When you do income tax for an estate, there's a clearance certificate you can get from the federal government. And many estates don't bother because the beneficiaries are the family. They know their parents' matters very clearly. On matters that, if I were an executor in an estate, I would require one before I distributed the money, because unless it were my parent. But many people and families, they're the sole beneficiary. You wouldn't even think of getting that. Well, now you may have to get it in order to get a clearance from the provincial government. So this is an emerging area. It was amazing to see nobody knew the answers. And the other thing they're trying to get that the last speaker talked about is the joint tenancy thing. People have been able to put their houses in joint tenants with their children to avoid probate fees. I have always personally been very concerned about that because the probate fees are pretty small compared to capital gains. And if you actually gave a share of your house to your child and they're not living there, when you sell it, that part that the child owns will be subject to capital gains. If it's not a true gift, then it should go back into the estate and you pay probate fees anyway. And that's what your last speaker was right on that. He was right on how that works. And the Supreme Court of Canada has had 2 decisions over the last few years on this whole issue of joint tenancy and ownership, and it's a matter of fact. So I remember a number of years ago when I was a lawyer in Mississauga, on the same day I had 2 motions about whether money given from a parent was a gift or was it a loan. And I'm glad to say that I won both motions, and they were different facts. So in one case, the court said, this is a loan, and the other case, they said it's a gift. So that's the issue. And again, back to the last speaker, he's absolutely right. This is just litigation lawyer money all over the place. So you want to be very careful. The other thing with joint tenants, bank accounts, we had a client well in her 80s who was a very smart woman. What she had done is left all of her bank accounts jointly equally to her 5 children. So if she died, it would automatically go to that child. One of her daughters predeceased her. And she came right away and changed her will. She understood, because what would happen is, what she intended to happen was that when she died, there were 5 children, 1/5 would go to this daughter, and if the daughter predeceased, it would go to her children. And that's what her will said. That wasn't going to happen because this was a designation at the bank. So as far as the bank was concerned, it just went to the daughter. And when the daughter died, that 1/5 share would come back into the estate. So it's these decisions that people think are easy, just put it into joint tenants, just put it into joint ownership. They're not as simple as they sound, and they really have to be thought out. So with that, I wish I could tell you something funny about estates. Maybe they're just funny in the way they are. I don't know, but they're. It's quite among the lawyers there the other night. Everybody was just talking about all the problems, about how the fighting in families, and I'm telling. Again, the last speaker, I didn't get to meet him. He was on his cell phone, so I didn't get to meet him. But he had some really good points that people need to talk to their children. If they're going to give something to one child more than the other, they probably need to talk to them so that everybody understands the game. And we gave one of our sons some money to buy a house. He's living in Calgary. And we very clearly told the other son why, how much, the whole thing, and made sure that that was approved. Because they get along. But things like that can really end families. So anyway, any questions? Okay, yes.
The compensation for power of attorneys
Yes.
that you discussed, does that apply? The previous speaker said there was no compensation allowed on the personal care power of attorney, but there was for financial.
No, there is some compensation in personal care. Because again, the client, can you imagine waking up one morning when you're the mayor of the municipality and somebody has left you as power of attorney for personal care and money? It's like having a target thing on the back of your head, but I had no choice. And it was a great experience because I got to go down to the Toronto Rehabilitation Hospital and see how it worked and spend time with him. But yes, there was compensation for that. So it's an interesting, there can be compensation. Again, everything is subject to the court. Yeah, yes.
You said about, in your experience with your sons, about, giving one child more or something and explaining it. What if the other person doesn't agree? Can they still contest? Or do you say, it's agreed upon, or does they have to sign something that they agree at that time?
Yeah.
Can you repeat the question for the people?
Oh, sure. The question is, like with my sons, where you give money to one and not to the other, even though you have explained it to them, could the other contest? What happened, we just made sure that we equalized it. I mean, one got money at one point and we equalized the money in another way to the other one. No, when you make your will, if you're capable, you can leave your money the way you want as long as you provide for your dependents. So your spouse and any dependent children. And from the cases, that's probably under 26 or so where they're, in school, or a special needs child you would have to provide for.
Now, what is classed as special needs?
Well, no, somebody you're supporting who's dependent upon you. And that's an interesting issue because that could be a subject of litigation as well. Just it's a very interesting question if somebody's living with you and being dependent. But it's not going to be somebody who's just living with you and, really could get a job. Yes?
You were talking about the inventory that has to be reported to the Ministry of Finance.
Yes.
What do you do for things like wedding rings, like personal jewelry, and if the spouse is the beneficiary, they automatically get sort of all of the personal effects in the house. But I understood that you had to report jewelry that was owned by the deceased. And how would you value that?
That's what they're saying, and that is one of the questions we had for the ministry the other night. It sounded like they were not requiring us to get them appraised. But again, you could easily have a $10,000 diamond ring. So that's an emerging issue. I wish the ministry good luck if they're going to try and follow through with stuff like that. Just good luck. And the bicycles, I wish them good luck on too. Yes?
I have a pretty basic question on a power of attorney. If you had a power of attorney for someone and then they moved because the power of attorney had their address on it, does that invalidate the power of attorney?
No, it doesn't. No. As long as they were competent when they did it. The other thing with power of attorneys, we do have people, that say they're concerned somebody might contest it, and we suggest they get a medical letter. I had a 91-year-old client said he was concerned recently that somebody might contest his power of attorney and his will. So I said, maybe you should get a medical letter. And he said he didn't want to do that. And then he called and said he would. So he has a medical letter, and that really made me feel a lot better as well, actually. But again, you can be competent at any age. Age is not a factor, but that is another way if you're concerned that somebody might try and overturn your power of attorney because you're not capable.
These new
spouses? Or?
Yes, they could, yes. Yeah, yes.
Probate between spouses?
Well, not really. If you have everything in joint with your spouse, if your house is joint and your bank accounts and everything are joint, there may be no probate. There's another way of avoiding it. You can have multiple wills. So, for example, we have a client who has a will for her property. She has a will for her limited companies. She inherited her husband's limited companies when he died. And she has a third will for all her toys. She's got some antique cars and boats and jewelry. And so we've called them, primary and secondary wills. Or now they're saying probated wills or non-probated wills. But that's the other way of getting around with it. But between husband and wife, like if everything's in a wife's name, for example, and she dies, the husband, even though he's the sole beneficiary under the will, would have to pay the probate fees. Yeah. And there are reasons, like some people, if the husband's in business or the wife's in business, they may not want they may want to isolate their assets for creditor reasons for some reason. But then there would be probate fees. But again, the probate fees, although people are trying to avoid them all the time, in the scheme of things, they're not huge compared to capital gains and other things. Well, for example, today I had an estate of 540 odd thousand. I think the probate fees are in the range of 7,000.